This is Ask Todd on the Financial Exchange Radio Network. If you have an existing estate plan or are in the market for one, Todd Lutsky is here to answer your questions and help you plan for later life. Ask Todd is presented by Cushing & Dolan, serving Massachusetts and New England for more than 35 years, helping families with estate and tax planning, Medicaid planning, and probate law. Visit CushingDolan.com. Now, here's Todd Lutsky.
As promised, we're now joined by Todd Lutsky for Ask Todd. This is the segment where you get to ask your questions to Todd Lutsky live on air. Anything related to your estate plan or lack thereof, this is your opportunity. We've got the phone lines open at 888-205-2263. That is the number to call to ask Todd your estate planning questions right now. Again, that number is 888-205-2263. Last couple weeks, we haven't had enough time to get all the way through, so get dialing early, get in line, and we'll get to you. Again, 888-205-2263 is the number. Mr. Lutsky, how are you today?
I am doing wonderful. And you?
Pretty good overall.
Oh, yeah? What's going on?
Well, I ate an abacus yesterday.
An abacus?
Talking to my parents, and they told me that it's really on what's on the inside that counts. And so I went that direction.
Eat one of those, yeah. That makes sense. Yeah.
Everything's great, though.
Yeah.
Todd, I want to talk to you a little bit about retirement accounts and how they relate to the estate tax.
Yeah, they're tough apples.
Is there any way through estate planning that someone with retirement accounts, IRA, 401k, Roth IRA, whatever it might be, is there any way to potentially reduce one's estate tax burden that they might incur, through holding those retirement accounts, or are they kind of stuck with it?
Yeah, so I guess when you're looking at IRA accounts, there's lots of components, right? First and foremost, remember, there's an estate tax, as you're mentioning, Chuck, and an income tax. So already right out of the gate, we have to think about two types of taxes when you're dealing with an IRA, so it makes it a little more complicated. And by the way, I'm just going to throw this out there too. You didn't ask about it, but a Roth IRA is still an IRA. And so as much as we think in our minds, oh, it's tax-free, that's what I understand about Roths, that's true. So when I'm dealing with a Roth IRA, I have one less tax to deal with, meaning when you withdraw the money,
okay,
it's income tax-free. But what people forget when they say tax-free is that there's still the estate tax side of the equation.
Sure.
Right? So many people, right, think, oh, well, it's a Roth IRA, so it's tax-free. I don't have to worry about it. But it's still included in your estate when you die because you own it, after all. And therefore, it is subject to the estate tax, even though it's not subject to the income tax. So just keep that in mind when you're doing it. Now, if we're talking about the estate tax side for both IRAs and Roth IRAs, to reduce the debt, to reduce your estate tax, there's really only one way to do it, right? If you leave your IRA to your spouse, which most people will do, and it's okay. It's a great income tax way to leave your IRA. No question about it. But it's a horrible estate tax way to leave your IRA. Why? Because if you've got $1 million IRA and you just leave it to your spouse's estate just went up by $1 million. It's not sheltered. So that's just adding to whatever your spouse has in her own right. Follow me? So it's subject to estate tax. If you, on the other hand, want to leave it the designated beneficiary to your family trust, and inside the family trust, it hits the Q-tip share, I'll call it the marital share, but it's a Q-tip, then it can still come out to the beneficiary, your spouse, over her lifetime, which is what you want from an income tax perspective, but it's sheltered in the trust when she dies for estate tax purposes, so at least you're winning now on both fronts, not harming the payout for income and sheltering it from being included in her estate when she dies if she has not spent it all.
Talking with Todd Lutsky from the law firm of Cushing and Dolan. Again, the number to call to ask Todd your questions about your estate plan, 888-205-2263. That is 888-205-2263. Still a little bit of room on the phone line, so again, get calling if you do have a question for Todd. That number again is 888-205-2263. Todd, when you're looking at, I guess, again, just sticking with kind of the estate tax side of things, what about other assets that might not be retirement accounts, after-tax investment accounts? Is there a different approach that is utilized there in terms of trying to minimize estate taxes?
Yeah, I mean, after-tax investment accounts, please, a much simpler answer, thankfully, please just retitle those while you're alive to your family revocable trust and or to your irrevocable trust to the extent you want to for Medicaid nursing home plannings. Just put it in there, and now it will be avoiding probate and sheltered for estate taxes.
Talking with Todd Lutsky from the law firm of Cushing and Dolan. Again, still a little bit of room on the phone lines at 888-205-2263. That's the number to call to ask Todd your questions live on air. We're going to take a quick break right now, but when we come back, it's going to be right to your questions with Todd. That number one last time is 888-205-2263.
Ask Todd with Todd Lutsky every Wednesday at 10:30, only here on the Financial Exchange Radio Network. Todd Lutsky answers your questions about estate and elder life planning every Wednesday at 10:30, right here on the Financial Exchange Radio Network.
Right to your calls with Todd Lutsky. First up, we got Sal in Boston. Sal, what's your question for Todd?
Hey, Todd, question about inherited IRA.
Mm-hmm.
I heard you can turn it into a like-kind IRA in your own name, and you have like 10 years to declare the money.
Are you the child?
Yes.
Okay, so a parent died, and you're the beneficiary. Go ahead.
So if you do that, does that affect like your own IRA, contributing to it, or prevent you from contributing to your own in that year, or is this a
no?
totally separate?
I think this is what we're talking about here is not whether you're able to contribute to your own IRA or how much you're able to contribute to your IRA. This has no effect on that. This simply is about you withdrawing from that IRA. Meaning, again, how old are you?
58.
So you're 58. So your IRAs you don't have to touch them. You don't have to withdraw. You don't have to do anything with them. But this IRA, you kind of have to. Right? Depending on how old your father or mother was when they passed, but likely at worst case scenario, you have to take this out over 10 years, and you have to either start right now, and minimum distributions have to come out. Probably 1/10 would make sense from an income tax standpoint, but depending on whether or not your parent had reached their required beginning date, you might be able to delay the distribution and not make required minimums, but it still has to come out over 10 at the end of the 10th year. And you'd never wait 10 years to take it out because, you'd have tax-deferred growth for 10 years, but then you're going to get hammered in year 10 when you have to take it all out from an income tax standpoint. So no impact on what you can contribute that I'm aware of to your own IRAs, but you do got to focus on the withdrawing from this IRA sooner rather than later, and watch out for any penalties if you do not. Folks, IRAs, tough assets, tricky assets to deal with. This is why we put together a guide this month. Naming your estate and IRA beneficiary. When would you do it? How do you do it? Does it make sense to do it, right? This is a situation where if you want to now reduce estate taxes by sheltering these for IRA purposes, you want to not get an adverse income tax when the beneficiary takes out the money. That's the required minimum distributions. And at the same time, if you have a surviving spouse, you want the surviving spouse to be able to enjoy the money, access the money, but if they get sick even the next day before they go into the nursing home, not at risk for the nursing home. which is way better perhaps than just leaving it directly to the spouse, in which case it would be at risk for the nursing home and less to the children. Lots to think about with an IRA, folks, from an estate planning and nursing home planning perspective. Pretty new stuff here. Get the guide, 866-848-5699 or legalexchangeshow.com. Again, 866-848-5699 or legalexchangeshow.com.
Todd, I got another one queued up for you here. Let's go to Bob in Worcester. Bob, you are on with Todd Lutsky.
Hi, Todd. Good morning. I'm considering putting my rental property in a trust with a spendthrift provision that states something to the effect that the assets shall not be subject to sale or transfer in any manner. Is this going to make it difficult for my beneficiaries to eventually sell the property at some point down the road?
Well, I think you're comparing apples and oranges, right? So the trusts have language in it regarding what the trust's powers are, the trustee's powers are. I don't mind having the spendthrift language in there. That's certainly a great idea to put in your trust. I may suggest that the rental property go into an LLC first, and then the shares go into your trust. That way, in case there's a lawsuit, you are going to have creditor protection from that tenant. Rather than being sued personally, you would be sued, that LLC would be sued, and your other assets would not be at risk. To your point, again, selling when the beneficiaries get it, if the trust says, hey, pay it out to your kids and let them do what they want with it, then there's absolutely no restriction on selling it. Even if you hold the asset in trust, again, forgetting the spendthrift language, that doesn't really impact this. You simply have language in there that says, hold it in trust for my kids for their life to give them creditor protection and divorce protection. The trust would still generally have the ability to sell the property or not sell the property. So I don't think that's going to be a problem. I hope that helps a little.
Todd, I've got another one here for you. Let's go to Lynn in Springfield. Lynn, you are on with Todd Lutsky.
Hey, Todd. Good morning. Thank you for taking my call. Mm-hmm. I have a problem. It's a very good problem, but it's a problem nonetheless.
Okay. We like problems.
Well, here's a good one for you to work on. I am 61, almost 62. I'm retired. I've been retired for a couple of years. Mm-hmm. I've been drawing off of my 401k. Mm-hmm. My 401k currently has about $1 million in it. Mm-hmm. And what I've drawn down, I've made back up because the stock market's been doing pretty good.
Okay.
I have about another $500,000 in cash, a property, a parcel of land that's worth about $500,000, and a home that's worth about another $1 million. So I have ample means, and this is before 401k, Social Security and a small pension.
Are you single?
I'm single.
Okay.
And I have one child.
Okay.
So I have a lot of stuff, a lot of moving pieces, and I know that I live very simply.
Okay, so now try to ask the question. Just ask the question.
I'm just trying to figure out how to best minimize my income tax in the future when I start drawing off of Social Security and continuing to pull out of my 401k, and then minimize my estate tax for my child when I pass my assets along.
So a couple of things, and I know we don't have a lot of time left, but a couple of things to point out here. One, from an income tax perspective, there's not really a lot of planning to do there. Maybe sitting with your accountant, maybe sitting with a financial advisor might help you. But as you withdraw money from your qualified plan, it's always taxable. And, your other investments, if you invested in income tax-free municipal bonds or something, might reduce your income. But I can't really address the income tax side of that equation. But on the estate tax side, we can. I guess if I ran the numbers correctly, you're somewhere around $3 million-ish, maybe a little more in total assets. Good news is federally you don't have any estate tax. I don't even see it being a problem in 2026 when the exemption drops back down to $7 million, give or take. I think you'll be fine. And even in Massachusetts, if I assume you live here, so if you're in Massachusetts, it's also not a really big problem because the exemption went up to $2 million. So, yeah, you're over a little bit, but, do we want to start thinking about lifetime gifting? And by the way, under the new estate tax legislation, there's no more cliff rules. So we're able to make gifts and be able to still get a credit and reduce our Massachusetts estate tax. So, yeah, there might be a way to do some gifting, but we'd have to balance that, of course, with the idea of a loss of a step up in basis. But most importantly, maybe you want a trust. If it's not revocable, you want to add some nursing home protection to protect some of the non-qualified assets and focus on living off of the qualified assets so that you can now add nursing home protection at the same time.
Mr. Lutsky, thank you so much for joining us today.
Always a pleasure.
This has been Ask Todd on the Financial Exchange Radio Network. Ask Todd with Todd Lutsky has been presented by Cushing & Dolan, serving Massachusetts and New England for more than 30 years, helping families with estate and tax planning, Medicaid planning, and probate law. Call 800-393-4001 or visit CushingDolan.com. The views expressed in this segment are solely those of Cushing & Dolan. Armstrong Advisory does not provide any legal or tax advice. Please consult with your legal or tax advisor on such matters. Cushing & Armstrong do not endorse each other and are not affiliated.